Steps to follow after someone dies when you have an original will in your possession. Hi, I'm Darren Findling of the Probate Pro, and an individual has died and you have the original will. What do? Well, first let's break a myth. The myth is that if you have a will and you're identified in that will with the authority to make the decisions, we call that person the personal representative, that you somehow avoid probate, that probate isn't needed. That myth is just not true. I guess that's why it's called a myth. The fact is, probate is required, and in fact, the will is used in probate for purposes of identifying how the estate will be administered and who will serve as the personal representative. The will does not avoid probate. Rather, the will is the guidebook to get you through probate. Now, probate is a process through the probate court, and first determining whether there is a need for probate is based on whether there are assets that are in the person who died's name that have no named beneficiary and no joint owner. If it's just in their name, then there very likely is a need for probate. Bank accounts, houses, investment accounts, cars, etc. There would be a need to get those assets through the probate process and then ultimately to the people that are entitled to inherit it. Now, what happens if there's no need for probate and you have a will? Because if there is a need for probate, it's obvious what you do with the will. When you file the petition for probate or the application, you attach the original will with the filing. If there is no need for probate, what people do not realize is that there is a legal responsibility to deposit and deliver that will to the probate court. You're saying I have to still go to probate court with an original will, even though there may not be ever a need for probate? The answer is yes. There's a statute, MCL 700.2516, that provides that a custodian of a will, that means a person that has custody of a will, has a duty with reasonable promptness to deliver the will to the probate court, either personally by walking it in or through registered mail. And the probate court then deposits that will. It may sit there in perpetuity. It may ultimately get used if somebody ever does open up probate. So there is a duty to deliver an original will to probate court within reasonable promptness upon the person's death. Now, the person who fails to do this can be held in civil liability and can be guilty of contempt of court and subject to the penalties of contempt for failing to do so. So it's really an important step following death that if you have an original will, we call those wet ink originals, that you deliver to the probate court for deposit. Not for the opening and commencement of probate necessarily, but pursuant to the statute that I referenced, 700.2516, you're depositing it with the probate court for its deposit for future use if necessary. And if nobody ever opens up probate, it simply will be sitting in a safe at the probate court in perpetuity. So following the death, a determination of whether probate is needed or whether there is no probate, but under each circumstance, if you have an original will, it gets filed or deposited with the probate court. If you have further questions about probate, reach us at 833-PROBATE or visit our website at theprobatepro.com.